My name is Tim Menchen. The topic that I looked into relates to workplace privacy, um, and more importantly, how much an employer should be allowed to monitor their employee, um, depending on the device, either be it an employer-owned device or a personally owned employee device. Now, oh, privacy is always a hot topic in the information technology world. I feel there's not a day or month that goes by that there isn't a hot court case about either about Apple creating a backdoor into their smartphones so that government agencies can access certain phones, or some stuff like this, privacy issues like that. There's always issues. While I wanted to focus on specifically the workplace, employer versus employee privacy rights. I work personally as a web developer, so I'm constantly, obviously, on a computer at work, which is employer owned. So I was kind of curious as to what rights should I expect of myself? What privacy rights should I accept of myself? As I go through, as I check a personal email, or if I look online for, to try to find a solution to a problem I'm having, or, just taking a break and going on a social media website, what expectation should I have for myself while I go through these things? So that's what I really want to look at. Basically, from the research I found, is that employees have very little rights to privacy when it comes to employer-owned devices. I understand this as employers want to make sure that their employees are putting, the technology that they provided and the time that they're, giving them isn't being wasted or being put into dangerous areas that could hurt the company. And the thing is, though, under law, employers are legally able to monitor their devices, monitor their employees, and employees should be able, or should know and understand that employers very well may be doing this right now to them. So employer monitoring, what they're really looking for and how they obtain this data is they want to study employee behavior. They want to study, they want to look at the performance and the conduct associated with it, with their employees. And they do this by gathering these digital footprints. And basically what that means is everything that the employee does using an employer given device, whether it be a work phone or a computer or some kind of workstation or email server. The employer looks at all this traffic that goes in between them, and those are the footprints that that they monitor and they look at to see what exactly these employees are doing, if they're going on the correct sites, if they're going to the using the email correctly, and they're not doing it for personal gain or personal businesses, or or they're just fluffing around on the job. These digital footprints allow them to access and see what exactly their employees are doing. Like computer and workstations, more specifically, like computer and workstations. The employer owns the workstation or the computer. They can access basically anything on it. They can see what exactly is on the screen at any given moment if they have the correct software on there. They can view internet usage and see, make sure you're not going to, wrong sites, like I've said before. They can even monitor like idle time. If, you're locked out and they're wondering, like, well, the this employee was only, active on their computer for 3 hours today. Oh, what were they doing? They can see that information, make sure that you are doing what you're supposed to be doing on their workstations. Email monitoring. If the employer owns the email system, and that includes like web-based accounts like Gmail and Yahoo, they are allowed to review its contents, and they're allowed to review even deleted information, and they're allowed to review even private information that some email servers allow that, but they can still access that information, and employees need to understand that anything sent out can be reviewed by anybody. Now, there's been a lot of court cases on this, and most of them have favored in with the employers. Now, there's some stipulations that have occurred that there have been outside reasonings for why the courts have favored in the employee, like Stengart versus Loving Care Agency Incorporated and Holmes versus Petrovic Development Company LLC. Both of these had to deal with attorney-client privileges. They're very similar in that the employee had some legal issues of some sort and was in communication with a lawyer, and they wanted to bring the issue of employer monitoring those conversations. And in Stengart versus Loving Care Agency, the courts favored with the employee only because the employee was using a private email server. They weren't using a company one. Whereas Holmes versus Petrovic Development, the employee was using a employer given email system. So the court ruled that the employer can monitor that because they were using the employer's system. So really, a lot of these court cases, like I said, are favoring employers because they own that information. It's their right to be able to do with it what they want to. Now, another aspect that employers will monitor is telephone monitoring. Employers may listen in and monitor calls for business. And the only thing that's a little different about this is that some states will require that a notification occurs before the monitoring happens. California, I know, has added this. Just allows some kind of notification so that employees and whoever's on that call knows that it's going to be recorded for the employer. Now, but what's a little interesting here is that personal calls may not be monitored. Now, if you're using a device at work and you have no personal matter, the employer can't monitor that call. They are not legally able to, and that's what the Watkins versus LM Berry and Company. That's what that case was about. Was about personal calls. Another thing is that employers can even access phone records, but that shouldn't really come as a surprise, as employers can monitor and access pretty much anything. Now, with all these aspects, I think that employers should be able to monitor this information, especially because they own the technology and the systems and the devices, and they should be able to protect themselves from employee wrongdoing and employee carelessness. A lot of these employees are access to vital information and things that if they get out can jeopardize the company. So while I believe in privacy and I think that I do have to agree with the employers in this, and that employees shouldn't have the expectation of privacy when it comes to using these devices. Now, where it gets hairy is the bring your own device policy that a lot of companies go for. Now, bring your own device policies are becoming an increasingly popular trend, and because a lot of companies are expanding, and with expansion comes a lot more remote possibilities for employees. This allows, if an employee is remote, it allows them to stay connected to the company if they can use their own device. A lot of companies, might give or offer their own devices, but that becomes a hassle for employees because they have to use multiple devices, and it's usually the same device. They might have two phones, so that's kind of a negative for the employee to have to deal with that. But another reason why employers and companies go with this is it could save the company money, that they don't have to worry about buying these devices or buying the data plans associated with it. It's all on the employee. But while this is a popular trend, it does put companies at risk because you're putting company information on personal devices, which a lot of people aren't fully aware of the dangers out there that come with using these technology devices, and a lot of them are very unsecure. And with that, employers will assume a lot of risk that come, legal, security, reputational, anything and everything. Risks that come with bring your own device policies, and this includes because of device loss and information loss. If an employee loses the device that has precious company information on it, then now that can be potentially compromised, or information loss. A lot of employees like to go to Starbucks or a coffee shop to work. Those coffee shops are offering free Wi-Fi, but that's a very unsecure connection. And if they're transferring company information, then what's to stop somebody from taking that information and putting it against the company? So while I understand the trend, I think that employers need to be careful with allowing their employees to do this. Now, what should an employee expect though with bring your own device? While companies are making this more of a policy, a lot of them are having expectations and requirements that employees may find uncomfortable, and that some include the company being able to lock and disable and wipe their data remotely. If something happens, if they do lose their device, the company wants to be able to wipe it and clean it so that the information can't be accessed. Employers may want phone records or personal emails or social media information, or even messages. While the employee doesn't necessarily have to agree to this, and then they may not be a part of this bring your own device, and they will be stuck with having to use the employer's device. So it's a trade-off. It really is. The employee basically has to agree to these things that the employer wants versus being able to use only one device and make it more convenient on themselves. So a lot of employees feel uncomfortable about that. It really just depends on what your personal expectation of privacy, and this allows you to have a little bit more control over it. You can either be private or have some inconveniences, and that's really your option with these policies. So it's just really comes down to the employee having those expectations realized, and understanding the policy that comes with bring your own device. Now, basically, to summarize, employees don't have a lot of privacy expectations. And I have to agree with the employer in that they should be able to protect themselves, even when it comes, and especially when it comes to bring your own devices. I mean, yes, that is your personal device, but you have to assume risk when you bring on company information into your personal device. I mean, if you are, a employee of a company, you should have the expectation that, and if that information gets out that you work for this company, that you may be a target. And when you become a target, you need to be careful. I'm not saying that this happens all the time, but then again, it does. That we may not read about. So I have to agree that companies should protect themselves when it comes to these privacy aspects in the workplace, and also bring your own device. And as long as employees understand these risks, then there really shouldn't be an issue. Um, Employees should understand that companies want to protect themselves, and they need to protect themselves because they're always constantly under attack about something. So that's my stance on that. That's how I feel. Please let me know if you disagree, if you think that employees should have more expectation of privacy. Um, I see both ways, but I have to agree with an employer, with the company, to protect themselves. That just makes more sense to me. So please let me know if you have any other issues with it. Um, Otherwise, I had a great semester. Thank you, Professor Freeman. I hope you guys, have a great rest of your graduate career.